Our first guest tonight is Whitney Boan, criminal defense attorney in Florida, who's been following the battery charge case today against Donald Trump's campaign manager, Corey Lewandowski. She joins us now from Orlando. Whitney, hello. Let me just ask you, before we start talking about strategy, tactics, defense versus prosecution, just what is the legal standard? What does Corey Lewandowski have to prove himself that he's innocent, given what we know at this moment?
Well, pursuant to our Constitution, he doesn't have to prove or disprove anything. It'll actually be the burden of the state of Florida to prove beyond a reasonable doubt that each and every element of the offense of battery occurred and that he committed that offense. So he will not have any obligation to put on any evidence tending to prove or disprove anything. However, I would expect him and his lawyers to put on a defense to this and use several different approaches at that Donald Trump has kind of alluded to even already.
You're right to call me on having gotten that thing backwards, and thank you for doing that. What's the prosecutorial standards? What does the prosecution have to prove on the basis of that videotape?
Well, the charge of battery requires that they prove that either Lewandowski actually and intentionally touched Fields against her will or without her consent, or they can prove it by showing that Lewandowski actually and intentionally caused bodily harm to Fields. They don't have to prove both. I know there's been some tweeting by Fields about bruises and such. They don't have to actually even prove that she was hurt, that she was bruised. It really only requires that there was an actual and intentional touching and that it was against her will.
Do you know the prosecutor?
That's all that they really have to prove.
Do you know the prosecutor in this case?
I do not.
Okay. So
Jupiter is a little ways away.
Okay, I'm just curious because obviously, you know, we don't want to minimize the complaint that was made, and the charge is a serious charge, but there's obviously unwanted touching, a variety of sorts that occurs in Florida, including in that jurisdiction, every day. So do you think, speculate here, that the prosecutor felt, because there was a video, because it's high profile, the prosecutor felt that he or she had to bring the case, even though it normally would not be brought under those circumstances?
I'm not even sure that it would not usually be brought under those circumstances, but I think that it would be foolish of me to say and not credible that the politics of this and the huge public spectacle that's going on with the Trump campaign probably didn't play heavily into the impetus of doing this and pursuing these charges.
If you were Corey Lewandowski's counsel in this case and he said to you, look, I got to make this thing go away as quickly as possible, do you think you could plead this thing out pretty quickly?
I'm sure he could. I mean, honestly, he may be eligible for a pretrial diversion program.
What would he have to plead to, do you think, to get it to go away?
Well, he might not even have to plea. I don't know that jurisdiction's policies about pretrial diversion, but many jurisdictions throughout our state have programs such as pretrial diversion that state attorneys will often refer cases to, such as a misdemeanor battery like this. It might involve that she would have to agree with that referral. It would probably include an anger management class, some period of supervision, but at the end of that program, the charges could be dropped. If he's not eligible for that, it's very likely, if he has no criminal history, which I'm assuming that he does not, that he could enter a plea to something like a withhold of adjudication of guilt and court costs, where he would not be even convicted formally of the charges. It would be on his record, so to speak, but he wouldn't be convicted.
And just to clarify one thing quickly and turn you back over to John, when you say she'd have to agree, is that as a matter of law or just the reality of a prosecutor in a case like this?
It's usually the reality of the prosecution in terms of like the policies within state attorneys' offices, because of the public policy in terms of not wanting to do things like that in violent crimes that are against the will of victims. Right. It's not hard and fast by law.
Let me go back to the question I asked before, which was, according to you, the prosecutorial standard here basically says that if he engaged in unwanted touching without her consent, that he can be guilty of battery, right? The video is what it is. You've looked at the video, you've stared at it, right? So if Corey Lewandowski called you and said, here's what the video shows, what should my strategy be? Is it smart for me, Corey Lewandowski, to go out and say I'm innocent, when, at least on the basis of the standard that you just suggested, it seems hard to claim that he's innocent if that's the standard?
It breaks my criminal defense attorney heart when I hear about all this tweeting and this talking about it. everyone needs to be quiet. I do victims advocacy too. I can tell you, even on her part, she probably needs to stop talking about it too, especially in such a public forum. Donald Trump's comments, as much as it pains me to say this, are not that troubling to me, and I wouldn't be shocked if there was some defense tactic there, and even having him kind of publicly come out and talk about this in the way that he has today. Right. I don't like that Lewandowski's talking about it. I don't think that helps. Any statement he makes can be used against him in court.
Just talk a little bit
He's
more.
A party opponent.
Talk a little bit more about what you just said about Trump's comments. Why you think those are different than Lewandowski's comments?
Well, I think that they're different because, I mean, we can't pretend like there's not a political forum going on here and there's not a greater political discussion. And honestly, I don't know that it would have been my tactic to allow him to make comments like that. But truthfully, Lewandowski's attorneys probably don't have any control over Trump. If they conferred about it, though, I don't think his comments were really that troubling. I tend to agree with him in terms of watching the video. I find it to be a de minimis touching. I find it to be something that we would see commonly in press conferences in terms of kind of the hype and the amount of people, and everyone's running around and everyone's chasing after the subject who they want to speak to. But I did not find what appeared on the video to be consistent with what she has said in terms of ending with severe bruises or being pulled down to the ground. And Trump kind of made comments that I would have expected to make in a court of law if I was representing Lewandowski.
Right.
So it'll be interesting.
So that would be the core of your defense if you were actually the counsel to Corey Lewandowski. That's how you would try to defend yourself, given what we've seen on tape. We have about 30 seconds here.
What I would have to do is argue that this was not unconsensual, right, that this was not something that someone wouldn't have expected or that wouldn't be normal in the course of the facts and circumstances surrounding these individuals at the time this happened.
Thank you very much. We got to go. Coming up, the conservative radio host who Donald Trump didn't hang up on yesterday.